Well, hello and welcome to the first annual Green Rights and Warrior Lawyers Virtual Academy. My name's Stephen Wood. I'm the director of the Center for Law and the Environment at the Allard School of Law in the University of British Columbia on the traditional, ancestral, and unceded territory of the Musqueam Nation in what is now called Vancouver, Canada. This is the sixth of 9 sessions of the Academy, and we are joined today from New York by the courageous lawyer for the Ecuadorian plaintiffs in the notorious Chevron Toxico saga, Stephen Donziger. As we get underway, I would like to encourage everybody to introduce yourselves in the chat. This is a more interactive, intimate forum than a webinar, so we'd like to know who's with us. Introduce yourselves in the chat, including where you're coming from and which Indigenous people host you on its traditional territory, if applicable. Also, we encourage you to turn on your video cameras so we can see one another. The session is being recorded. It will be available on the Academy website where you registered and also on our YouTube channel. Stephen's talk will be followed by commentary from University of New Brunswick law professor Jason MacLean, and then some Q&A. We will invite you to pop questions or comments into the chat at any time, and then when the Q&A starts, you can put questions in the chat, or you can raise your hand and speak your questions aloud. When we are finished the sort of formal public session, we're going to stop the recording and just sort of transition into a more informal, intimate chat around the virtual kitchen table for those of you who want to stick around. We originally planned to have that in a separate Zoom room, but we are finding that that is unnecessarily complicated. And so we're just going to continue in the same Zoom room. You don't have to sign off and then sign back in with a different link. I'm now going to introduce our commentator, who will in turn introduce our featured warrior lawyer, Stephen Donziger. So Jason MacLean was a professor at the University of Saskatchewan College of Law and an associate member of the School of Environment and Sustainability there, before joining the faculty at UNB. He is a staunch and well-known champion in the fight to stop climate change. He's passionate about environmental protection and promoting sustainability. Much of his research focuses on environmental, natural resources law, climate change, and energy policy, also sustainability pathways and co-benefits. Before entering academia, Jason clerked at the Supreme Court of Canada for Madame Justice Marie Deschamps, practiced corporate and commercial litigation at Osler, Hoskin and Harcourt in Toronto, and international commercial arbitration at Sherman and Sterling in New York and Paris. Thank you for joining us, Jason, and over to you.
Thanks so much, Stephen, for the introduction and the opportunity to be here and to be part of this incredibly innovative and inspiring initiative. Well, it's my pleasure this morning to introduce really somebody in the environmental law field that really needs no introduction, but in case there are some people who are brand new to this field, it's my pleasure to introduce Stephen Donziger, who is a renowned advocate, writer, and public speaker at Donziger Law with a focus on addressing human rights abuses, and corporate malfeasance. He is part of a team working with Indigenous and farmer communities in an area of the Ecuadorian Amazon rainforest suffering from high cancer rates and other human ailments related to the massive oil pollution caused by Texaco, now owned by Chevron. In 2011, the affected communities, with Mr. Donziger as their attorney, won a historic $9.5 billion judgment against Chevron for the environmental cleanup of what experts consider to be one of the worst oil-related catastrophes in the world. Stephen Donziger is known for his, quote, Herculean tenacity by Businessweek, and that's probably an understatement. Stephen has been representing the affected communities since first visiting the region in 1993, when he was not long out of law school himself. I first encountered this case as a law student a number of years ago myself, and I've been following it closely and even writing about it ever since. So join me, everyone, in welcoming Stephen Donziger. Stephen. You're muted, Stephen.
Sorry about that. Thank you so much for that kind introduction, Jason. Been a great admirer of your work, and to Stepan Wood for organizing this really interesting speaking program, which I consider to be very important because, you know, it's very important we communicate with each other, that people who do this work, you know, share their experiences, and that we connect the dots, you know. And one thing I've noticed in my, you know, pretty long history now of working in climate justice, and specifically on the case against Chevron, is the other side wants to keep us divided, and they don't want us to learn from each other. So I salute you, Stepan, and the law school at the University of BC for pulling this program together. And I'm honored to be invited to take part. I'm going to speak for maybe, you know, 20 minutes about, sort of tell the story from my perspective. At which point we can get commentary, I think, from Jason, and maybe open it up a little bit for questions. I think we're going to start, though, with a very short 2-minute video so people can get a feel for the degree of the pollution problem down in Ecuador's Amazon that I've been working on for a number of years. So maybe we can show that first. I always remember a story Umberto talks about a lot of how when he was a little kid, there's an enormous river in front of the village where he lives in the forest, and one day it just became absolutely riven with black oil. When you see the river on fire that your people have depended on for 1,000 years because of oil contamination, you see your life and your future go up in flames.
What some environmentalists call the world's worst oil-related disaster.
My name is Stephen Donziger. I was there in Ecuador when indigenous groups and Amazon communities were fighting Chevron in an epic battle for justice. My first trip to Ecuador was in April of 1993. I went down with some lawyers and scientists to investigate reports that Texaco had dumped literally billions of gallons of toxic oil waste into the pristine Amazon rainforest where indigenous groups live. No one really knew what would happen as a result of the trip, but one thing that did happen is those who went on it all committed to trying to do something to address the problem and to help the people, and to hold Texaco, now Chevron, accountable for what looked like a massive human rights problem that was done deliberately. On my first trip, I was shocked by what we found. I expected to see pollution. I was shocked by the extent of it. Massive pools of oil, literally thousands of them all over the rainforest. The oil was on their clothes, it was in the air they breathed, it was in the food they ate, it was in the water that they drank. It was an apocalyptic nightmare. Okay, I'm gonna go ahead and proceed if that's okay. Okay. So that video, just so you know, was an excerpt from a news report made by Vice Video about 2 years ago. The full thing is about 10 or 12 minutes long, and you can get it on the internet on the Vice channel, the YouTube channel. It's called The World's Worst Oil Disaster Nobody Has Heard of. But the reason we wanted to show that was to just give people a sense of the extent of the contamination that we're talking about here. You know, I'm going to basically describe the problem, and then I'm going to explain what has happened through the law to get us to this point. And this is all going to be in summary form because this covers a 28-year period, if you can believe it. So the fundamental problem, as you can see from the video, is when the U.S. oil company Texaco went into this part of Ecuador in the 1960s, they used substandard drilling and operational practices that resulted in the discharge of literally billions of gallons of cancer-causing toxic waste, oil waste, most of it into rivers and streams that the local indigenous peoples and farmer communities had relied on for their drinking water, for their bathing, and for their fishing. So there was a decision by Texaco to pollute. We're talking about a contamination problem that is a function of deliberate design, not an accident, like say the BP spill in the Gulf of Mexico. And we're talking about long-term impacts, health impacts, economic impacts, mental health impacts, and a real diminishment of the quality of life in this part of the world as a result of the pollution that was left out there deliberately by Texaco, in my opinion, done out of pure greed, that is an effort to enhance their profits even beyond the high levels that they were already occurring at. So when I first went down and witnessed this, I really was shocked. And that was 1993. I had been out of law school for 2 years. And a group of us, I was very junior at that time, but a group of lawyers and others with far more experience than I, we all decided to file a lawsuit against Texaco in New York. And there began phase one of the three main phases of the case. Phase one took place from 1993 to roughly 2003. And that was what I would call the battle for a trial, the battle to get into the courthouse so these affected communities could have put in their evidence and have a neutral court hear it and hopefully rule in their favor and provide them some sort of remedy. This was simply, to me, a pollution case. It was a tort pollution case. Obviously, it had major implications for human rights, for environmental justice, for indigenous rights, but at core, it was designed as a simple tort case. There was nothing fancy about it. The claims were very basic, and they largely had to do with cleanup and personal injury. During this phase of the case, of course, first of all, Texaco had left in 1992 and left all this stuff out there where it continued to pollute. Their substandard infrastructure was taken over by Ecuador state oil company, Petroecuador. They kept operating pretty much along the same lines. And their main argument was the case should be heard in Ecuador because that's where the damage occurred. And our clients down there, the communities, most of them had never even heard of their own court system, never stepped foot in a courthouse in their country. Many had never even met a lawyer who even understood what the law was. The indigenous groups, until Texaco came, didn't even have a word for cancer in their native languages. Many of them lived very prosperously for hundreds, thousands of years with no money as we understand money. They were completely reliant on and part of the natural world and the forest down there. So when the pollution started occurring in the 1960s, 1970s, 1980s, all of that history and that tradition became extremely disrupted with awful impacts. And by the time we started the case in the early 90s, there were serious problems. So any delay, and I would argue that Texaco's main initial strategy was just to avoid a trial and get the case dismissed, or that didn't work, just delay it as long as they could, was causing a lot of harm to a lot of people. Ultimately, they won what I would call stage one. They got the case down into Ecuador, thrown out of U.S. courts where it was filed. By the way, it was filed in New York on the theory that the decision to pollute in Ecuador was made here in New York by Texaco, because that's where Texaco's headquarters were located, in White Plains, New York. However, it was sent back to Ecuador with one key feature that I would call, as I look back on this case, a major victory for the affected communities, which is that Chevron, by the way, had bought Texaco in 2001. So at the latter stages of this first phase of the case, it was Chevron was defending the case. They were forced by the US court to accept the jurisdiction of Ecuador's courts. So it was clear that as long as we kept going as attorneys, that we could and would have a trial in Ecuador. It was not our first choice, but it would be a trial. So we decided to keep going, and we, started a very interesting and I would say very effective collaboration with lawyers in Ecuador. And the case was filed down in a court in a town called Lago Agrio, Ecuador in 2003. And we were in trial 6 months later. And this was a major victory because it was very clear to me that Chevron and its legal team were extremely uncomfortable with the idea that a trial would happen and that they might have to actually litigate the case on the merits. They were so desperate to avoid a trial that literally on the first day of the trial, it turned out that their lead lawyer, who was based in the United States and was down there like managing their local legal team, met with the country's attorney general and got him to call the trial judge to try to persuade him to dismiss the case on the first day. And the trial judge refused. The case proceeded, but I got a taste of their bad faith when their first argument was the court in Ecuador did not have jurisdiction over Chevron, even though as an express condition of getting the case sent from the United States to Ecuador, they had agreed to accept jurisdiction. So it was very clear we were not in a normal litigation, that we were litigating against a party that employed bad faith or was willing to use bad faith arguments to try to somehow undermine the legal proceeding. I don't know if you hear that noise. I'm in the middle of Manhattan. It's noisy here. Then the second phase began in Ecuador, led by Ecuadorian lawyers. And, I thought this might take 2 years. Ecuador, you might know, is a civil justice system. It's not like Canada or the United States. We have common law systems. Judges do a lot of the work. There's field inspections, and we embarked on dozens of field inspections of contaminated Chevron well sites that ended up lasting several years because of the delays that many of which Chevron had engendered deliberately to try to sabotage the trial, but also because of the very nature of gathering water and soil samples, sending them to independent labs and the sort. To sort of make that phase of the story, a little shorter, because I could talk about it for a long time, it ended up taking 8 years. Chevron, about 2 years before the case ended in 2011, with a victory by our side, they vowed never to pay the judgment, and they sold off all of their assets in Ecuador in anticipation of losing, because the evidence, the scientific evidence, the testimonial evidence, the evidence was mounting, and it made them look very, very bad. So, their first line of defense, avoid a trial, failed. Their second line of defense was that the trial that started never end or go as long as possible. That failed. We got a verdict in 2011 from a trial court in Ecuador, ordering them to pay roughly $18 billion for what appeared to be the world's worst oil contamination. That amount later was cut in half on appeal, but the liability finding, the basic findings other than the damages were affirmed by their version of their Supreme Court, called the National Court of Justice, in 2013. So phase 2 ended with a resounding, and I would say historic, victory by the affected communities. Phase 3 then began, I would say, around 2011, and that involved really 2 elements. One is because Chevron wouldn't pay, the people of Ecuador needed to go to other jurisdictions like Canada to try to enforce the Ecuador judgment against Chevron's assets in those countries. It also involves Chevron's retaliatory counterattacks against our team with a particular focus on me. So first I'll deal with the latter point, although I want you to think about phase 3 in parallel. Chevron's real fear was judges in respected legal systems like Canada or the United States would actually rule that they had done what the Ecuador court found that they did do, which is deliberately cause a massive, horrific, we called it the Chernobyl in the Amazon, a contamination that was killing people and threatening indigenous groups with extinction and really causing irreversible damage to one of the most delicate, pristine, and important ecosystems in the world. And they didn't want people to think about that. So one of the things they did is they sued me personally back in the same New York court that we had originally brought the underlying environmental case in, where they had argued it should be in Ecuador. And they steered the case to a judge who used to be a defense lawyer for the tobacco industry. The judge, we later found out, had financial investments in the oil and gas industry, including in a mutual fund that was invested in Chevron itself. And they denied me a jury, and they sued me under a civil racketeering statute on the theory that all of the work we did in Ecuador was a racketeering conspiracy designed to extort money from them because the case was a sham. And of course, nothing could be further from the truth. It was all just a construct they created out of the law that was false. And they tried to launder that through the US court system, through this pro-corporate judge who despised the idea of people who do this work, that is human rights plaintiff side work. And they ended up suing me for the most money anyone's ever been sued for in US history, which was $60 billion US. That case then took a number of twists and turns, but without a jury, I had no chance. And it resulted in a finding by this US trial judge that I had committed all sorts of felonious, horrendous criminal acts, including extortion on the theory that the case was a sham, money laundering on the theory that the monies I had raised to fund the case because the case was a sham were not legit, and I was guilty of money laundering, wire fraud on the theory that I took money from my law firm and sent it into Ecuador to pay case expenses for a sham case, et cetera. It was all just a falsehood. And without a jury, there was not much I could do about it. But to avoid a jury, they had dropped all the money damages claims prior to the trial. So I didn't owe Chevron any money, and the judge issued this long opinion, basically trying to sabotage and trash the whole case in 2013, which had, a hugely disruptive impact on my life. You might have heard what a slap suit is. This was like the mother of all slap suits, designed to silence me. But in the meantime, the Ecuadorian team and me and the other lawyers kept going. Like, we went into Canada and we won a unanimous decision from Canada's Supreme Court in 2015, giving the Ecuadorian communities the right to try to enforce their judgment in Canada. And all of this was very disturbing to Chevron. Ultimately, it resulted in them going back to the US trial judge who did the racketeering case, getting him to order me to give them my computer and cell phone and confidential information, attorney-client information. I asked the judge to hold me in civil contempt, which was the only way under US law you could appeal a civil discovery order. For months, I asked him to do that. I could not turn over this to Chevron. I had ethical duties not to do that to my clients. But this was done by deliberate design to put me in an impossible conflict between obligations to my clients and my legal obligations as a lawyer to court decisions. Ultimately, he finally held me in civil contempt, which is what I wanted. He started to impose fines on me that literally in 40 days were in the billions of dollars, until he realized that looked ridiculous. He cut those way back. In the meantime, I appealed, having been held in civil contempt, I appealed that finding to the federal appellate court here in New York. And while my appeal was pending, the judge charged me with criminal contempt of court, because I didn't comply with an order that that was pending appeal based on the appeal I had filed. And he took the charge to the U.S. attorney, the normal prosecutor in Manhattan, who refused to prosecute me. And the judge then appointed a private corporate law firm to prosecute me in the name of the U.S. government. And it turned out later that that law firm, Seward and Kissel, had Chevron as a client. So I was prosecuted in the United States, and this is the only such prosecution I've ever seen in this country, and I've never seen one in Canada, or really any other country in the world. I was prosecuted by a corporation in the name of the US government, not just any corporation, but the corporation that I had helped my clients hold accountable for a very significant monetary judgment based on their pollution in Ecuador. So Chevron's goal was to take these court decisions against me and leverage them in the countries like Canada, where a parallel process was taking place to enforce the Ecuador court judgment, and try to sort of use it either for optics purposes or for direct legal purposes to convince Canadian judges that the whole case had a taint, that the whole case was a fraud, or if not a fraud, it kind of looks a little weird, doesn't it? That an American lawyer went down to Ecuador and got a multi-billion-dollar judgment out of an Ecuadorian court. There's a real, I would say, colonial mentality, like Ecuadorian courts somehow are not up to snuff. They're not as good as our courts. This had to be corrupt. There was like this presumption that it couldn't be legitimate coming out of Ecuador. And getting these completely unfair judgments based largely on false evidence against me helped them sort of create an ambiance around the case in Canada that was designed to completely undermine the view of the case, at least in some areas of Canadian jurisprudence. Ultimately, the judge had me locked up at home on a theory that I was a risk of flight. The contempt charge prosecuted by the private law firm was a misdemeanor, the lowest level federal criminal offense. There had never been one instance of a lawyer charged with a criminal contempt who had been held or detained prior to trial in the history of our country. I'm the first one. And for various reasons, I ended up living in this apartment with an ankle bracelet under detention for 2 years and 2 months before I could get a trial. And then once the trial happened, again without a jury, the judge locked me up pretty quickly. It's normal in a misdemeanor case when you have a legitimate appeal, as I do, and my appeal is still pending. Like the court doesn't make you serve your sentence until the appeal is heard, but she made me serve my full sentence immediately while my appeal was pending. And here I am now, over a year later, I served my sentence, including 45 days in prison. She gave me a maximum 6-month sentence. I finally was released on April 25th, but they still have my passport. They won't give it back, so I can't come to Canada to continue my human rights work. Throughout this process, they also disbarred me without a hearing where I could challenge facts, even though ultimately I did have a hearing where I could present character evidence about myself, where the neutral hearing officer recommended that my law license be reinstated, but it still hasn't been reinstated. So what's my big point here? Okay, well, where do we stand, I should say? So I'm going to wrap up right now. On the underlying environmental case against Chevron, it still exists. It's viable. It's been affirmed by Ecuador's highest courts, and there's no statute of limitations on enforcement actions. And the Ecuadorians, with lawyers other than myself, are exploring ways to get that enforced in various countries around the world, including possibly the country of Canada. In terms of me personally, I still have like this big thing hanging over my life, which is the civil case that where I was ordered to give them my computer is still out there. It's not active at the moment, but I believe Chevron, if it wants, could reactivate it, and the judge potentially could charge me once again with contempt and, you know, fine me or put me in shackles again. So, you know, I live in this kind of bizarre environment as a lawyer, but I still continue my work. I continue my advocacy, and I continue talking about this as much as I can, including in programs like today. I think it's really important people understand this goes well beyond me in this case, what's happening. It really has to do with whether our court system is going to protect the right of all of us advocates to be advocates. It's a free speech issue, really, at core. It's a human rights issue, yes, about climate justice, about indigenous rights, about pollution, but it's also a human rights issue about the ability to advocate, to speak, to hold the major polluters accountable for some of the awful practices they've engaged in, not just in Ecuador, but in many countries around the world. And I would argue that that is an issue intimately connected to climate justice, intimately connected to our duties as lawyers, or those of us who do this work, to be frontline defenders, doing work, supporting indigenous people, supporting First Nations, who are confronting the entities that are destroying the planet. So they want this to be the new normal. They want this to be part of a new corporate playbook where they can just prosecute and detain those of us who are effective in this work. And I'll point out, before I'll stop, that in Canada, there was the inkling of this happening several months ago when a judge in Vancouver gave, I think, the Canadian National Railway the right to privately prosecute an indigenous hereditary chief who had violated an injunction not to block a railway through his nation's ancestral lands. Now, it turns out that Canadian Railway, after a big uproar, decided not to take the opportunity to prosecute this gentleman. But I believe there are going to be attempts to copycat what Chevron did to me in the United States, in Canada, and other countries, if we all don't understand what this is, and if we all don't speak out against it. So I'll stop there. Thank you so much.
Over to you, Jason.
Thanks, Stephen. I can't help but think as I listen to your story and your analysis of it, that it's a harrowing story, and it highlights both, I think, the transformative potential of law, of an independent judiciary, of the courts, and of human rights and environmental lawyers to affect the kinds of change that we desperately need in order to achieve environmental and climate justice. But at the same time, your story also highlights not only the limitations, the normal, what you might otherwise consider to be the normal mundane limitations of litigation that law professors will talk about, delays, technical proceedings, the sheer inequality of resources in this fight, but it goes beyond that, and it suggests that there can be perils, and indeed personal perils, in taking this work into the courts. And I like where you left off the talk, because it suggests to me that we're at a fork in this pathway, and that we have, and the sort of the collective we in our society, that we have a fundamental choice to make in terms of what kind of system and what kind of model that we're going to have. And so I'd be, I suppose my first comment is, and I have two, and I'll just say them both, and then, but they're really questions to you, to talk a little bit more about what you see as how to engender and inspire more advocates to come together in a way that would best ensure that we do everything that we can to choose a model and to support a model that protects speech, that protects advocacy, and that really that protects the independence of our legal system. I really think as an environmental law scholar, a big part of my focus has been to try and show that the legal system and the law can't be meaningfully separated from larger political and economic interests and norms. And I think your story in particular, the sort of what's happened in phase 3 of the story, as you've told it, is a stark, if incredibly regrettable example of that. I guess my second question is, and it really goes back to something you said at the beginning, which you're part of your motivation for continuing to do this work and for speaking at events like the one that Stepan is created here, is that fossil fuel interests and polluters' interests, you noted at the beginning, would prefer environmental and human rights advocates to be divided and seek to divide the movement. And I was curious for you to say some more about that. And in line with my first question and comment, what you see being on the front lines of ways to try and bring this movement together to make it more forceful. So you've had a quick break, but really,
Okay.
I want to hear more. Over back to you.
Thank you. Just a couple of points. First of all, for those who are thinking about doing this work, I want to emphasize that what happened to me is not normal. And as harrowing as it sounds, we're good. We won. Okay. This is happening because we won, not because we lost or did something wrong. Okay. They're basically, we had a situation here in the US of a corporate capture of a pocket of the New York judiciary that was then turned on me. And whether they get away with it in the long term is a very open question, because we're fighting to expose it and to hold those accountable who did it. Okay, and there's various ways we're doing that, which I can talk about, but it's not over. Okay, that's number one. Number two, I don't think that what happened to me would happen in most rule of law countries in the world. Okay, I don't think it would happen, for example, in Canada. I don't underestimate that Canada is a fossil fuel country. And I get it that a lot of judges come out of that corporate law firm world, just like here. And they're going to be sort of predisposed perhaps to not want to help activists or lawyers who do this work. But I have litigated or watched lawyers we work with in Canada litigate, and I've never seen like the level of insanity, of vitriol that can happen in the civil justice process in the US when some of these very aggressive law firms, rather than actually litigate the claims, they're like, oh, we're just going to destroy the life of the lawyer and leave his or her clients defenseless, and the case will just go away without the lawyers. And that's really the playbook that they're trying to use here. And of course, they use elements of that in other countries, including Canada. I get it. But actually locking up a lawyer like this, I don't think that that is a super likely thing to happen to others who do this work in countries known as rule of law countries. I just want to be clear about that. However, the attacks on lawyers and attacks on protesters takes place on a lot of levels. I mean, I'm kind of an obvious extreme example, But like in the United States, we have all sorts of laws being passed at the behest of the fossil fuel industry at the state level that enhance penalties, criminal penalties for acts of protest that really are protected by free speech just because they happen to take place at an oil installation, a refinery, a pipeline. And, you know, there's one example of a woman named Jessica Resnicek in the US state of Iowa, who gummed up a pipeline in an act of civil disobedience and was deemed a terrorist and given a 5-year sentencing enhancement by a federal judge appointed by President Obama. You know, so this sort of special status given in the United States courts to the fossil fuel industry, as opposed to, say, other industries, is becoming more and more a thing, more and more obvious. And I think it's more and more of a threat to those of us who do this work. And what they really want to do is use those laws, use what they're doing to me as a weapon to try to intimidate others into not doing this really important work. But I would really emphasize that you can do this work without being jailed. You know, I never imagined this kind of thing could happen, but I think a lot of it has to do with, again, the particular judge and how this sort of went off the rails. And I would argue played out in very corrupt fashion that this country has never seen before. And I'll add, look, I mean, there's a lot of problems in the criminal justice system of the United States and Canada and many countries. Like there are other people who get victimized by the system in the United States who have it far, far worse than I do. I want to be clear about that. But this kind of thing, like a corporate prosecution, to me is an animal I have never seen before. And I'm just telling you that it was invented by the industry or by the industry lawyers, these clever lawyers, as another tool that in their arsenal that they can use against our movement. On the second point about unity, you know, they tried to isolate me from the movement, right? They didn't want people to invite me to speak to programs like this. You know, they wanted people like Stepan and others to think I was not a credible person because I had this civil finding against me that I had committed fraud in Ecuador, which was just flat out untrue. So, you know, I've tried really hard to tell my story. And I have a lot of support now, which I didn't have 3-4 years ago, including, you know, like 68 Nobel laureates have signed a letter demanding, you know, my exoneration, as have 120 NGOs in the US, Canada, and around the world. I mean, a lot of people know about this now that didn't know about it before because they went after me in the way that they did. You know, and I would argue, just as a little tip for the practitioners out there, like, never look at an attack on you as anything other than an opportunity. You know, try to turn the attacks into opportunities. And what I tried to do when they locked me up is I got on social media and really started fighting for myself in a very public way. And it ended up that I'm close to 200,000 Twitter followers, and, you know, I have support. And when you have support, it's a lot harder to bring you down. So I don't know if that directly addresses the questions posed, but I'll leave it at that for now.
No, I think absolutely. That's really great. And I think, thank you for that. And I think it's really important that you emphasize to this next generation of environmental justice warriors that, you know, we're trying to train in law schools and other programs to not take the wrong interpretations and the wrong lessons out of your story, and that your story is ongoing and that the fight is ongoing. And I think that's really great. That's really well taken. I'll turn it back to Stepan.
Well, thanks. I actually want to open the conversation up now at this point for Q&A from audience members. So just as a reminder, you can pop a question into the chat, or if you're not feeling shy, you hit the raise hand. Someone has already figured that out in the reactions, and you can speak. So I see Gareth. I should be able to unmute yourself, but if you're having difficulty, we'll help you. And
Thank
go
you.
ahead. Are we able to see you? Is that possible?
Oh, yes, sorry, I'm not feeling particularly well today, so I just wanted thank you, Stephen, for this incredible and deeply profound explanation of your circumstances. I wanted to touch on particularly the what I see as an disturbing trend towards the privatization of law, and particularly in international forums, how this is happening. And everybody, I'm sure, in this call knows about, investor state dispute settlement and forum shopping and all of the various ways that companies can weaponize the law. But when you talk about the issue of sort of a company, a corporation being hired, like a private interest being hired as a prosecutor, it just makes me very concerned that there's these sort of norms that are sort of becoming increasingly common. And I wonder about how, us as activists, we can fight against this general trend, which is like the corporatization of law.
Well, the fact you're aware of the trend is a good start, because a lot of people, a lot of these trends are designed to be hidden. A lot of them are hidden in the esoterica of the law and technical arguments. You're seeing this now a lot before the US Supreme Court. It's sort of hard to notice how bad it is sometimes, because it's like, oh, that's just an issue related to, authority for the executive branch to engage in regulatory action. No, it's actually about climate change and saving the planet. Or like my private prosecution, which is just mind-blowing, right? Like by a Chevron law firm, is really an issue of the appointments clause of the US Constitution and whether there was executive branch supervision of the private prosecutor. In the meantime, thousands of people are dying from pollution in the Amazon. And like, we're talking about the appointments clause, like that's what it gets reduced to. And I think as lawyers, as advocates, we need to understand the power of language and communication and sort of keep people's eyes on what this stuff is really about. Yeah, you got to have sophistication to argue those, legal issues related to various provisions of the Canadian law and the US Constitution, but you also can never let that sort of reduce what cases are really about to cold issues of language, so it's our duty, I think, to keep the people who are impacted in the forefront. And I think the trend toward the increasing privatization of law, which we see in the United States a lot. I mean, for example, Enbridge, the Canadian pipeline company, spent, I think, $9 million US financing police forces in Minnesota who were arresting indigenous protesters who were protesting the Enbridge pipeline. And like in my case, you saw a corporation, take over the prosecutorial machinery, and you're seeing this trend more and more where corporations are actually financing and controlling public functions of government. So it's a worrisome trend that we need to be aware of. Again, I think they want it to kind of happen little by little, that people just think, it's not a big deal. It becomes the new normal. Well, we can't let it become the new normal.
Anyone else? And while you're thinking about it, I'll throw a couple at you, Stephen. The first is really just taking you up on something you said earlier, which is, can you tell us a bit more about the strategies that you are deploying in the counterattack against this this brutal corporate attack on your role as an advocate? And the second would be, throughout this entire process, how have you managed your own personal, mental, and physical well-being? It must have been such a challenge, and I just wonder how you've come through and so resilient. You could answer those, or we could go to another question that.
I'll try to answer them quickly. I mean, I think in terms of where we go from here, there's a lot of ways to hold them accountable. They require time, money, emotional commitment. So all of these strategies are being considered. It's unclear where we're going to go with this. I think the most important thing, though, is that the affected communities have the resources they need to get the recovery that they have earned, such that they can do the cleanup of their ancestral lands, because a lot of people are hurting and dying right now. And that's really where I'm trying to keep my focus. In terms of the personal stuff, you know, I don't know what to say. I adopted a method during my 2+ years of home detention to survive. One of the things I did every morning was I worked out, on the floor of my apartment. I got some weights in here and I just moved my body around. The second thing I did is you can't see it, but right in front of me, there's like 3 windows that look out onto a side street in Upper Manhattan. There's like a building across the street, but like I do get sun during the day, and I would open the windows. I took the screens off and I'd like stick my head out. I'd read with the paper or book just to get some sun on my face. And then the third thing I would often do is, like, the end of the day, I was working all day, by the way, like with my lawyers, fighting for myself, fighting the case basically, and also doing media interviews and just trying to build up support. So I worked hard all day. A lot of people, by the way, think you're on house arrest, you have nothing to do. Like, I was extremely busy. And at the end of the day, I would go take a shower, even if I didn't really need to sort of demarcate the detention phase of my day from my evening. And at that point, I would then, get dressed with some different outfit, put on shoes, go into our kitchen, and we would cook, maybe have a glass of wine, listen to some music, and have a family dinner. Or if my son wasn't around, my wife and I would have dinner. And we just tried to act like we were going out, even though we were in my kitchen. So we did that a lot. And, over time, I actually felt fortified by the detention because I was getting so much support. It was stunning to me how people were reacting to this, as I think I'm hearing kind of in your voices today, just listening to the story. And it was so uplifting and encouraging that I never really felt bad during the entirety of my detention, other than when I got home from prison and they started to monitor me. Like, I was getting 10, 20 calls a day from this monitoring center asking me if I was home. And also at all hours of the night, I couldn't sleep, and it became it was not good, but I was very, very determined to get through it, and not only get through it, but use it as an opportunity. Remember, I said, never look at an attack as anything other than an opportunity. I use it as an opportunity to test myself and to try to build the interests of my clients out further than they otherwise would have been. And I can say, as I look back on it, I'm so proud of how it played out, and yeah, I am resilient. I am a very resilient person, but I would argue that all of you, if you're probably imagining, like, what would I do if that happened to me? I bet 90% of you would do the same thing I did. People just step up to meet challenges when you're committed to a cause. And by the way, I didn't enjoy it. Please don't get the impression I liked it. It was painful. It was painful to watch my son, who, when it started, was 13. He's now 16, to see his dad in an ankle bracelet for 3 years, and we couldn't do anything. Couldn't travel, couldn't go to the park, couldn't go to a game. Painful. But what situation of adversity have any of you not met that you got through, that you grew from, that became a better person? And that's how I looked at it the whole time.
Thanks for that. Paula, I saw that you had raised your hand. Would you like to do that again? Do you have a question?
Yes, please. Thank you, everyone. And Stefan, what I can say, thank you for your terrific presentation and for sharing with us your incredible personal trip, I would say, not only professional, of course. I'm from Bolivia. I'm a lawyer working, I would say lawyer and academic. Now I am in more academic life, but of course trying to also provide a kind of support, no, with my colleagues. And thanks, Stefan, because the first time that I heard about you, Stephen, the first question came to my mind was how he's managed everything from a mental perspective point, I would say. And you really give us a nice question, be resilience. I guess that all in life it's about that, but for sure, thank you for stress that is it has been, and normally it can be also a painful job, especially for people working in developing countries. I know about the other colleague from Ecuador. I not remember the name, that he also has been attacked, no, in Ecuador, while you were doing also or going through the same pathway in Canada, United States. So my question would be, now that you know what happened with the case, with your experience, with the experience also of colleagues in Ecuador, if you look back, what you could do in a different way for your experience, because you mentioned probably what happened to you didn't happen in a rule of law country, but in Latin America, our systems are as you properly presented here, they are what they are, and resources are there, companies are there, and now, well, from a different part of the world. So we probably have and will have the same kind of issues, not as bad as Texaco, of course, but also there are many issues related to contamination and companies, etc., in many countries in Latin America. So what do you do in a different way, and what do you would expect from colleagues during all these years doing with your case?
Thank you for your question. A couple of things. One is, I do think these collaborations cross-border are really important. First of all, I had to grow into like seeing my role as one that was very subordinate to the communities. When I first went to Ecuador, I'm like, oh, I'm going to help these people save themselves. And now I'm like, no, we're collaborating. And I work in a service posture to the leaders of these communities whose lives are at stake. It sort of requires, I don't know how people are trained, how y'all got your legal training, but where I went to law school, you're trained to go out and lead and sort of run the case. And sure, there are provinces of every case that you need to be a lawyer to manage, right? Like technical stuff. But we also always saw the case as a component of a much larger campaign for accountability that included advocacy outside of court, including journalism and media and education, public education, and that kind of thing. And I think that was key to our success. And I also think it was key to Chevron being really bothered by what we did, because they were embarrassed to be exposed. I think the cross-cultural thing is really important. I would always tell people in Ecuador that, they're suffering the consequences of a terrible decision made by a company in my country, in the United States, that we had to do this together, that it's all part of the same picture. The polluters want people in different countries to be totally divided. For example, they want to flee Ecuador and just challenge the Ecuadorians to go chase them into other countries around the world, counting on the fact that these communities with virtually no money have no way to contact lawyers in those other countries to start these enforcement cases. That's what they bank on. Like when they decide to pollute deliberately, they kind of bank on, well, the people affected could never hold us accountable. They'll never figure it out. And I think that we figured out a new model, not new, I mean, it's other people have obviously collaborated across borders, but like, I think we did it over many years in a really robust way, based on mutual respect, not without our challenges and problems. We had many of those, but ultimately it was based on mutual respect. And it was backed by an economic model that included wealthy donors and pools of capital that were able to fund the case for a long period of time. Because the other thing they count on is you're going to run out of money. You're never going to be able to hang in there. They count on you giving up. That's what they count on. They don't ever want to, they don't ever actually think they can win on the merits. They know they can't. They just don't want you to win. And if it turns out you can't win, then they win, right? Even though they don't technically win on the merits. So there's all these things you need to understand about how they operate and about how these litigations play out. But I would say, the main thing about what we did that I think is applicable to Bolivia and to other countries is, we need to all try to create these cross-border alliances, understanding that we have a lot to learn from each other. Canada has mining companies, for example, all over the world, probably in Bolivia. There needs to be collaborations, for those types of cases with Canadian lawyers, Canadian campaigners, and Bolivian communities and Bolivian lawyers and Bolivian campaigners, not to mention others from other countries who can support. So that's why I said at the beginning, and thank you for pointing this out, but I do think connecting all the dots and communicating and, being able to build these teams is the most vital part of our work. They want us to live in isolation. I'll make this final point. A lot of people say, and I think Stepan might have said this at the beginning, is like, Stephen won this big case. Okay, I want to just give you my take on that. In the West, we always want to have that one person who does an amazing thing. Okay, well, it's not my case, and I didn't win the case. I helped the communities win their case. At this point, I don't own the case. As a matter of fact, there's a court order that I can't even get paid if there's a recovery. And as an aside, they've taken all my money anyway. I mean, I'm basically living like my clients when I went down there in 1993, who had no money, but were, pretty happy because they could live off the environment. And like, I have no money at this point in my career because Chevron took it all, but I'm pretty happy. And I'm really proud. And by the way, it's not like I'm starving. We have a defense fund that funds my expenses, but I don't even have a bank account, So my point is, these collaborations are practically necessary, effective, and I can tell you from a personal career standpoint, really enriching in terms of the life you want to lead. And they're critically important. I don't know if that answers your question. I'm like kind of going on and on.
Yeah, no, I thought that was a really brilliant answer, Stephen, and really emphasizing the power of those collaborations, both in terms of getting results for affected communities, but also in terms of shining a light on the outrages, committed by corporate defendants against the advocates who try to, help the communities hold them accountable.
And I'll just say this: what I'm talking about is exactly what should happen in every one of these community-based environmental actions, whether within one country or one community or one province or cross-border. You got to build teams of collaborators that can be effective.
At this point, let me just suggest that we're going to bring the formal part to an end, but don't leave. Do stick around. I have a couple of formal things to say, and then when we turn off the recording, basically the cameras are off. Well, I mean, our videos are still on, but that's the time when, those of you who have joined in the audience can really have a chance to have an intimate, informal, relaxed conversation with Stephen about his experiences, and with Jason as well, without the pressure of being recorded. So just to let you know that we've got a full day ahead of us, and at 9 a.m. Pacific, which is around 45 minutes from now, our next session will begin with South African earth jurisprudence pioneer Cormac Cullinan, followed then 2 hours later with the Nigerian environmental justice lawyer and 2022 Goldman Prize winner Chima Williams. And finally, 2 hours after that, the great Maori legal scholar Jacinta Ruru. And there's still time to register and jump into any of those sessions by going to the website GRAWLACAD 22, GRAWL ACAD 22. And also any university students in the audience, or if you know any university students, it is not too late to join our innovative, collaborative brainstorming and research exercise that will carry on for the rest of the month of November, called the Green Rights and Warrior Lawyers Inspirathon. And you can find information about how to join in that fun exercise at the same website.